What we're going to be doing today is we're going to talk about what is the blended family and what are the considerations in planning for the blended family. Estate planning after divorce and remarriage, co-ownership of assets and homestead, deciding who will inherit after divorce and remarriage and how they'll actually inherit it, qualified terminal interest trusts, trusts for children, independent trustees, guardianship, multi-generational planning, and when you should actually update your estate plan. Estate planning lets us deal with passing the assets to beneficiaries when we die and making sure that someone's looking after us and our kids if we become incompetent. The blend comes into play if you get divorced and remarry or if you have children outside of the marriage. Now, you may get the yours, mine, and ours situation where you and your spouse both bring children into the marriage and then you have one or more children together, or maybe there are just stepchildren involved or adopted children. Maybe even you adopted your spouse's children or related children, maybe from a deceased relative. First thing we're always going to look at when we're doing estate planning is what are our goals and priorities. For some, it might be how to best save on the estate taxes, while for others it could be about protecting the family from creditors, mismanagement of money. When you've got your blended family, you have to decide whether you're going to treat your own children the same as your stepchildren, or whether you're going to leave your stepchildren out of your plan or somewhere in between. Now, you may leave those stepchildren out because they're going to inherit from their own parents, or you just may not have the relationship want to leave them anything. And then you always want to look at the question of, when you've got the blended family, how do you actually incorporate your spouse, your new spouse, into that situation? Now, some people may leave everything to their spouse, and some might leave the bare minimum, and there's always something in between. So in order to accomplish your goals, you have to be very, very careful how you choose your fiduciaries. Fiduciaries are individuals or companies that you entrust to liquidate your estate, manage your assets, make distributions to beneficiaries. And often the biggest mistake you can make is choosing that wrong personal representative or trustee. Because if the person's not strong enough to handle beneficiaries who are at war or becomes too emotional, you can create major problems. Families in general are very challenging when money is involved, but if you mix in the blended family, you've got a lot of extra challenges. You've got the natural children who have that inherent feeling that they should inherit everything, and then you've got the new family and steps who potentially can muddy the water. So you always want to consider what your assets are, what you're going to give to each particular beneficiary, especially when you're dealing with a business or real estate. We're going to talk about the business a little later on and how you would work that into your plan when you're dealing with a blended family. And also when you're dealing with the situation and anything else in estate planning, you always want to look at what are the estate tax ramifications for anything that you do. Let's say you already have an estate plan in place and you get divorced. What do you do? Well, it depends on the state you live in whether the law itself gives you the actual answer. There are, in the state of Florida, if you're divorced, then anything that you left to your spouse in your will or trust is nullified, which means if you had your spouse as the beneficiary of your estate, once your final divorce is done, then it's as if your spouse died before you, and the next people in line get to inherit. Even though it's automatic, I'm always in favor of getting your estate planning attorney and your financial planning advisor to review all of your legal documents, all of your financial assets to make sure that everything is going to go under the new plan without that ex-spouse. For instance, Florida law changed in the last few years, and it took the same approach to insurance and other retirement assets, which means if you had your spouse on your life insurance a few years ago, if you got divorced, the spouse actually still got to inherit under the policy. Whereas now they changed a few years ago that now it goes the same as with will or trust, and the spouse loses their right to inherit even if you don't change that beneficiary. Personally, I wouldn't want to rely upon that. I would want to make sure that I've changed the policy. Especially if you remarry, you want to make sure that you want your new spouse on instead of the old spouse, because that could get kind of ugly. Also, if you held any joint assets with your first spouse, then you want to change that. That's not an automatic situation like it is with a will or trust or insurance. So if you have this joint asset, let's say it's a joint bank account, you owned it as either tenants by the entireties or a joint with rights of survivorship, if you get divorced, you still own it with your spouse. And then if you die, your share could end up going to your new spouse who will own it in conjunction with your old spouse. I'm thinking that's not the greatest idea. You want to make sure to separate everything out and change all ownership so you don't have that problem. So obviously you want to update your beneficiaries, retitle your new accounts, and then one thing that I always suggest to clients, and it's probably not that common to be suggested, is you want to revoke your power of attorney if you're getting to, even if you are separating. The first thing you want to do is revoke the power of attorney. Now the power of attorney is what gives a person the right to handle any of your financial matters for you. So that's why if you're in a situation with a spouse, soon to be an ex-spouse, you don't want them to have any control over your finances. So the first thing you do is you do a document that's called a revocation of power of attorney. You've got to have it notarized. Where you want to send that is you want to give that to your attorney, to your financial planner, to your insurance agent, to your banker, anyone who you would normally do business with, so that you know that your soon-to-be ex can't make any financial moves without you. The other thing you might want to do, sometimes it's overkill, but it's not a bad idea, is to actually record that revocation in whatever county you live in or own any real estate in, because that'll put people on notice that that power of attorney is not usable anymore. Now, if you've done a prenuptial or a postnuptial agreement, then you want to consider when you have your new spouse whether or not to actually give them power of attorney. So you want to consider that along with everything else, because that could play a factor in your whole estate planning. And you don't want to create additional friction with your kids. There are different types of co-ownership that you might utilize in an estate plan and can also be used with spouses. There's two that I'm going to talk about today. One is joint tenants with rights of survivorship, which basically says two or more people can own any sort of asset jointly with right of survivorship. So if one dies, the others reapportion their interests to own the rest of it, and it automatically passes. You don't have to do probate or anything like that. And this can exist between spouses or between any unrelated individuals as well. If you with ownership, you don't mind that the other person inherits everything, then it's fine. If you get divorced, then if you own that rights of survivorship with your spouse, then it ends up being that each one of you will own half of it, just like we talked about before. And then if you die, your ex-spouse could end up owning an asset either with your new spouse or with whomever inherits under your estate. So something called tenants by the entireties, or TBE, not available in every state, but the main reason to have TBE is because it's great for creditor protection. You can only have it with spouses, and it's essentially the type of asset is joint with rights of survivorship, but it is only available for spouses. If you get divorced, you no longer have joint with rights of, you no longer have tenants by the entireties. It skips right down to what we call tenants in common, where you and your ex will have equal interest that you can pass, to your heirs, but only half that interest can be passed. About the homestead. There are some states that have homestead laws, and Florida is probably the strongest. If you and your spouse own a house, if you own a house and your spouse is not on title, but that's where you live, and that's your homestead, then you actually have, under Florida law, strict restrictions on how you can actually dispose of that house when you die. For instance, if you have minor children, whether you or not, you cannot disinherit your minor children from your homestead. If you have minor children and a spouse, then your spouse gets to make a decision upon your death. Now, mind you, this is only if your spouse is not on the title. What happens is that your spouse gets to say either they'll take what's called a life estate in the property. They get to live there for the rest of their life. They pay all the expenses. And the children, meaning all of your children, get the remainder, but they have to wait to actually take possession until the spouse dies. The other choice is the spouse takes a 50% interest and the children take the other 50%. That's probably more common when they're thinking of selling the property, and the reason behind that is if you own 50% of something and you sell it, it's so much easier value than if you have a life estate. So it takes out a lot of the problems of valuation and everybody not getting along. If you're still married, even if you're separated, and it doesn't matter how many years you're separated, your spouse does not live with you. If you die, your homestead is still able to be by your spouse. So if for whatever reason you separate and you don't anticipate getting divorced quickly, you may consider doing some sort of formal agreement where the spouse waives the homestead, because otherwise that spouse could end up owning either half your house or taking a life estate when you die. Again, if you do a pre- or post-nuptial agreement, you can waive the homestead specifically in the agreement and take away this situation. So we covered if you have a spouse and minor children. If you have just a spouse, then you cannot leave your home to anyone other than the spouse. So you can't leave it to your brother, you can't leave it to your sister. You can leave it to your children if your spouse is gone, but you cannot leave it to your children if you have a spouse. With adult children, you can completely leave your adult children out. There's no problem with that under the law. Estate planning can be extremely complex, especially when you're dealing with blended families. You have to ask yourself if you want your new spouse to inherit, or do you want the kids from the first marriage to inherit, or somewhere in between. Now, if you want your children and stepchildren to inherit the same, or do you want you to leave your stepchildren out completely? People usually come somewhere in between. I would say majority of my clients will leave their stepchildren out because they're figuring that the stepchildren are going to inherit from their natural families. Your own children will feel entitled that they should inherit, and there's going to be, generally, as a general rule, there's going to be a problem between the families if you give inheritance to stepchildren the same as you give to your natural children. It's just a natural way of life that people are going to be, warring over money. So you have to be extremely careful on how you handle that. And the other thing you need to do is you have to figure out, where does my new spouse fit into this situation? Am I going to leave my spouse everything? Because if I leave my spouse everything, at the spouse's death, they're going to leave it all to their own children, and my kids are going to be cut out. But as a general rule, most people don't want to leave their spouse with nothing. So there are ways that you can accomplish. We're going to talk about a trust in a few minutes. There are ways that you can accomplish both goals by taking care of your spouse and still keeping your money in your family. When people die, there's so much chance of there being strife and people suing each other. So if you want to avoid conflicts, then you need to really have a very well planned out estate. You need to select your trustees and your personal representative very carefully so that those people are prepared to deal with the fallout after your death. Because you want those people to be able to make distributions to your heirs without having to deal with the conflict of the interfamily situation. In my opinion, the most useful estate planning tool when you're dealing with a blended family is what's called a qualified terminable interest trust, or a Q-tip. And here's why. Let's say you're married and you love your spouse and want to make sure that he's taken care of when you die. But you want what's left to go to your children and your children when the spouse dies. That's what you use the Q-tip for. not only can you do everything we just talked about, but you can maximize estate tax savings as well, because anything that you leave in this type of is going to actually pass through the surviving spouse's estate, not yours. So this works very well if your spouse doesn't have much money in their own name and you do. You can actually end up shifting some of your assets and take advantage of certain estate tax rules. Now, when you use the Q-tip, you have to be very careful because there are very strict rules that apply to the Q-tip. Number one, your surviving spouse must get all the income from this trust at least annually. And a special election has to be made with the IRS if you're going to treat property as Q-tip. If the election's not made, then you're not going to be able to take advantage of this. Now, the Q-tip will take care of the spouse, but then you've got to think about, well, what about your kids and your grandchildren? How do you want to handle what you're going to give them? It's very common in trusts to leave everything with some mandatory distributions. For instance, I'll let my kids have a third of my estate or a third of my trust when they turn 25, then half the balance at 30, and then at 35 they get the rest of it. It's not a bad plan, but you've got some issues with that. Number one, if you leave them what we're calling there is mandatory distributions. Let's say my child is 30 and they're going through a divorce and now they're entitled to distribution. Well, guess what? That's going to fall in as part of the divorce, and their soon-to-be ex-spouse could be taking some of your money. Or let's say your child, for whatever reason, is not doing very well mentally or financially. If they're going to get a mandatory outright distribution, then it could be a real problem because that money could be spent on the wrong things. It could be used for drugs, alcohol, who knows. So the best way to do this is kind of to control from the grave and leave everything in trust, but leave it with discretionary powers of the trustee, and let the trustee decide when the beneficiary should get money. Now, if you do that, I will tell you that you're supposed to have what's called an independent trustee, so that person is a non-family member, and that's probably the best way to handle the situation. But I'm, again, a firm believer in most situations where you should make these discretionary benefits from the trust, because it protects everyone. And then you've got, inside the trust, you'll always have what's called a spendthrift clause, which basically doesn't allow that beneficiary to say to, let's say, the Ferrari dealer, I've got a trust set up for me. I'm just going to pledge my interest in that trust so that you'll give me a Ferrari. The spendthrift clause is going to protect that beneficiary, so you're not going to have to worry about that. We earlier talked about choosing a trustee, and that's a pivotal part of any estate plan. And the trustee has the responsibility to manage the trust assets and distribute them according to whatever the language of the trust says. Now, mind you, you're the one that came up with the language for the trust. Now, you might name what we call an independent trustee, and I mentioned that a little earlier, or you can name a family member. I always recommend you put both. You name a family member and you name a co-trustee as an independent trustee. The independent trustee is going to be more neutral. They're not going to get involved in the emotions of the beneficiaries. They're going to be able to make some more prudent decisions. But I'm always a little wary of just naming an independent trustee because, for the same reason, that they don't really know the emotions of the family. So if you put two together, name your independent trustee, name a family trustee, then you really get the best of both worlds, because somebody will actually know the beneficiaries but is not going to be the only one harassed about benefits from the trust. So you've got an independent party who can think more clearly, but you've got a family member who can contribute the information as to who's the beneficiary, what are their needs, are they stable, and things of that nature. What's critical when you name trustees is always have successor trustees as well. That means whomever you named as your initial trustee, you name a whole series of successors. The more, the merrier, because you don't really want a situation where you end up with no trustee of your choosing. when you're dealing with your blended family, you also have to think about guardians. Now, you can have your own guardian. That's if, God forbid, you become incapacitated. Who's going to handle everything for you? You're always going to want to do what we call a designation of pre-need guardian, where you can name, now you can separate out your guardian of the person and guardian of the property. Guardian of the person, that's the person who's going to be in charge of physical custody. If it's for you, where are you going to live, who's going to handle your health care, what is going to be your socialization, things of that nature. And a guardian of the property, well, that's going to be the person that actually handles your money, who's going to manage your money. The court is going to appoint these people after some due diligence and a hearing, and the guardian actually has to account to the court each year. So there is some sort of checks and balances system. When you have minor children, generally under the age of 8, happens if you die, who are they going to live with? Who's going to parent them? Who's going to take care of their money? So you've got the same thing, guardian of the person, guardian of the property. When you've got a blended family situation, your spouse may be the right person to make the decisions about where you live or where your child lives, where they school, what's the socialization, what kind of health care do they get. But you may not want that person to also be in charge of the money. So if it's your own situation where you're the one who needs the guardianship, then you may name either an outside person as the guardian of the person, or you may name one of your children, but that child may not be the person you want to actually take care of your daily needs. So it's a little different with an adult. When you've got minor children, the bigger issue is if you're not married to the minor child's, let's say the mother, and you leave money, well, you probably don't want that mother to be in charge of the money for the child. It's okay that the law is going to give them the guardianship of the child of the person, but as far as guardian of the property, you're going to want to make a decision that's going to be better for you. Whom would you want to control the money for the child? So when you're dealing, even under no blended family, you always want to evaluate whether or not it's a smart idea to name the same person as guardian of the person and guardian of the property. I'll tell you as a practical matter, it's better if it's the same person, but it may not be the right decision with you and your children. The law of guardianship in Florida, and in other states it differs, is that you can name a guardian as long as they're a relative, they can live anywhere. If they're a non-relative, they cannot reside outside of the state of Florida. And the example I always give is my best friend in New York cannot be the guardian of children in Florida. One of the biggest assets in an estate is generally the business. The business is usually relied on to keep the family going, and it's usually a big issue with the heirs. When it's a closely held business and one or more family members are in the business, then you need to make sure that your estate is together in such a way that whoever is involved in the business gets to stay in the business, and those who are not involved in the business stay out of the business. But if you do that, you have to make sure that you've compensated or arranged for compensation to the family members who are not involved in the business. Now, there's a lot of things you can do for that. You can do buy-sell agreements. You can do life insurance to make sure there's enough money to buy out the non-involved family members. And by the way, this also works for situations where you're actually involved with, a non-relative as a partner. That partner, I can assure you, when you die, has zero interest in running the business with your family. So what you need to do is you need to make sure that you've got planning in place that covers the eventuality that you may die or become disabled, and your family needs to be compensated for the business, but your partner or your involved family members can actually run the business without interference from, the stepchildren or your new wife or your new husband. You may have a situation where several generations are involved with your family business, and you have to decide and it's very hard to actually decide this, but you need to make proper planning to account for this. Do you want your business to actually stop when you die? Do you want it to be sold, let your family have the liquidity, or do you want the business to continue? Can continue for the next generation, for generations to come. If you plan appropriately, then you can actually keep this going, assuming the business itself is viable. But if you don't plan, then chances are things are going to fall apart. People are going to argue. The value of the business is going to just plummet, and then you've left your family with, nothing rather than an extremely valuable asset. Last thing I wanted to touch on is, when should you actually have your estate plan reviewed? Now, there are a few times where you may benefit from a review even if you don't have to change anything. If you've got a well-drafted plan, then if you have an illness, you shouldn't have to update your estate plan. However, if that new child is with a new mother, then I would highly recommend redoing your estate plan, because for sure you have not accounted for the new spouse and the new child. If you have children with multiple mothers, then again, you need to make sure all this is covered inside your planning. Do you have guardians of the property for these children who are not the mothers of the children? People don't think of that, but it's pretty critical. If you're moving from one state to another, you certainly have to take a look at your estate plan documents. It's very likely that you're going to have to at least do some minor changes to the documents to reflect the new state.